This one's gonna do. Yeah. Listen. All we're gonna do today is arraignment. You've got a handful of charges. We're gonna do a not guilty plea for today. Okay? Then I'm gonna have you come back because we have to have discovery on your case and go over everything. It'll probably be in about a week or so. I'll have you come back to the office, go over everything and kind of discuss our options here. Okay? That's basically what the game plan is, since we haven't had a chance to talk beforehand about it, about the case, and because we don't have discovery. And given kind of the nature of the charge, it's definitely better to do it that way. Now, you got something on your mind, talk to me.
This is my second rodeo with this.
Okay?
So last time I was
You gonna go in or?
She's coming out, so I'm sorry if I'm in your conversation. My bad.
Mm-hmm. Yeah.
Was that missed call?
No. All right, go ahead.
Last time I was here, I made a statement, and the last counselor that they tried to issue me or whatever, he got upset. So I want to clear this up with you.
Do you know who it was?
I can't remember his name.
Was he here?
Yeah, he was here.
No, is he here now?
No.
Okay, then. I'll do that pass in the past then.
Well, he took my my actions personally, and I don't want that to happen between you and I. So prior to you asking me to sign anything, I do want to let you know that I'm not signing anything.
Okay.
And I didn't come here to plea.
What did you come here to do?
I came here basically to seek cause and action for these charges, and I really want a motion to dismiss, but you guys work for this courthouse, so I know what I have going on for me.
Thank you, sir.
I think you're kind of missing the point here.
Yes, ma'am.
All right. So, what's up? You need me for something? Oh, sorry. All right. So here's I'll kind of walk you through the kind of the process that's going to happen. All right. Now, up to this point, as far as I know, what's showing on our thing is that. Well, let me ask you like this: you have a retained an attorney. Is that correct? Okay. My understanding.
Last courtroom, the child told the state's attorney that I did not do this.
Okay.
Okay? She should have dropped it right then and there. They bumped the charges up. They're trying to fuck my life up, and they have me over here in Superior Court in front of a judge with a felony. I have a 2-year-old child. This is not a fucking joke for me.
Right.
So
here's, I guess, the main thing I want to make sure, because I want to make sure that we get everything correct. As I understand, the last time you were here, you did an application to have counsel appointed for you. Is that correct?
no, they tried to appoint.
And you said no.
I said I'm not signing the indictment, and he got upset.
All right.
Literally.
I don't worry about that part. My question
The
is.
judge got upset too.
Okay. Well, sit tight. That there's a way around that. My question is this: in terms of representation, you've got 3 options. Okay. Option number 1 is you represent yourself. Option number 2 is you ask to have counsel appointed for you. Option number 3 is you hire your own attorney. Now, you do have to pick one of those 3 options, but whichever one you want, that's the first thing I want to kind of clarify.
So why am I here to sign contracts then?
You're not just, we'll cross that bridge in a second. I'll explain to you what the process is, but which one of those 3 options would you want to do? Because in other words, when you're going through this process, and this is a process, do you want to have counsel? Do you want to have an attorney represent you?
There's no corpus delicti. I shouldn't need counsel.
You're gonna have, if you do not want to have counsel, you can say so, and then you can represent yourself if you choose to do so. I just need to know one way or another if that's what you're choosing to do. Okay, that's all. So are you asking to represent yourself at this point, or do you want to have a lawyer to assist you?
I want the charges dismissed.
That's not an option today. I need you to make a choice, one of those 2 choices.
I mean,
And I understand, I can literally see that you're very pissed off about it, and I understand it. My question though is this: you got a charge. In order for us to go forward from this step to the next step, okay, which is to fight this case, you're trying to achieve a goal, but in order to achieve the goal, there have to be certain decisions that you have to make before that happens. So, like I said, the first one is you've got a criminal charge. You ain't gotta like it. I hope you don't like it. You don't like it. The question though is this: do you want to represent yourself, or do you want to have an attorney?
represent myself.
Okay, now, here's what's going to happen. This is the next step, and I'm giving you, this is free advice, okay? Here's what's gonna happen. You're gonna walk in there, you do not have to sign a not guilty plea necessarily, but you will have to either you plead guilty or you plead not guilty. If you remain silent, the judge will enter a not guilty plea for you.
Wait, that's practicing law from the bench. That's illegal.
No.
That is constitutionally
No, hold up. And this is what I will tell
prosecutory
you. No, it's not.
misconduct.
No,
it
it's
is.
not.
It's definitely.
No. So here's the other thing that I want to kind of lay out for you. If you're going to tell me what I think you're going to tell me, okay, the shorter answer is what you indicated. That's not correct. Okay, statute says if a person stays mute, then the court enters a plea of not guilty.
The
Now,
statute is totally separate from the Constitution because
No. All the stuff that you've been taught is wrong. I will tell you that. Okay, I can absolutely positively tell you that, and the reason I can tell you that is because I've been here before with other people who've told me the same thing. It's not what your interpretation of law is. Literally at this point, no. So
I'm from Chicago, man.
Yeah, so
when somebody doesn't show up and there is no evidence, it's thrown. It's so simple. Now I come here and I drove 5 hours to come here.
From where?
Savannah.
Okay.
Second time.
Right.
It's not like I'm trying to evade the issue.
Right. Nobody is, but you have to. You have to. So what's going to happen is today you're going to walk in. Judge is going to say how you plead. You either say not guilty or you stay silent. Judge will enter your not guilty plea, and he will send you home. That's all that's going to happen today. There is literally nothing else. Now I will tell you this: not only as one lawyer to a civilian, but also person to person, man to man, Chicagoan to Chicagoan. All right, I'm telling you this right now. Should you represent yourself? No, it's a terrible idea. But if you choose to do so, that is your right, and nobody will stop you from doing that. But understand, the rules that you are under, that is not the law in Chicago. Damn sure ain't the law here. But I want to at least make sure that today you don't get screwed over. So what I'm going to suggest you do, but this is up to you. When the judge calls you out, he'll basically say, how do you plead? You can either say not guilty or you can ask to remain silent. Either way, you'll get your not guilty plea entered, which is a denial of the charges, which is what you do want to enter. That's what you're saying. And then you'll be free to go. That's the first thing. Then after that, the state will turn over their discovery. There may be some discussions, negotiations, who knows? I don't know how, because I don't know the details of your case. That's going to be the next step. But for right now, I need you to understand that one way or another, there's going to be a not guilty plea put in file today. One way or another. And that's not a bad thing at all. That's what you want to happen. Okay? You want the denial on the record. So that's all that's going to happen today, okay? Now I'm going to take you on back here for a minute. You sit tight. When Judge brings you back down on the bench, we'll take care of that so we can get you out of here, because I know you've been sitting here since 8 o'clock and you're ready.